no-fault or no-blame divorce is a much more straightforward and amicable approach to separation, in that couples will be able to file for divorce or civil partnership dissolution without having to place the blame on their former partner to prove the irretrievable breakdown of the marriage or partnership. Before the 6th of April 2022, it was necessary to provide a reason for the breakdown of a marriage by citing one of 5 facts: adultery, unreasonable behaviour, desertion by a party, 2 years separation with the consent of the other party, or 5 years separation without the consent of the other party. From the 6th of April, this is no longer necessary. An application can be started by one person as a sole applicant or by the couple together as joint applicants. They do not have to give a reason for the divorce, other than a simple statement that the marriage has irretrievably broken down. This is confirmed within the application itself by simply ticking a box. The option of challenging the application is also now severely limited. There is no opportunity to contest a statement of irretrievable breakdown, although there can be a challenge based upon a technicality, for example, jurisdiction or the marriage was not lawful to start with. But these situations are going to be very few and far between and only irrelevant to a very small minority. The language used in the proceedings has also changed. The person who applied was called the petitioner, but is now called the applicant. The decree nisi, the document which confirms the entitlement to a divorce, has become the conditional order. The decree absolute, which dissolves the marriage, is now called a final order. There is now a mandatory minimum of 20 weeks between starting the proceedings and applying for the conditional order. As before, the final order cannot be applied for until 6 weeks after the conditional order. Yes, the legal process is now easier. The new law has several consequences for separating couples, including no more blame within the divorce application. If both parties agree, they can make a joint application for divorce or dissolution, which can assist with an amicable separation. No one will need to worry about their partner contesting the divorce or dissolution and then forcing them to go to court, saving considerable time, costs and stress. With the new timescales, most couples will have to wait about 6 months for their divorce or dissolution to finalise. This time is intended to be a period of reflection for both parties to consider whether they truly want to separate. During this time, couples still need to make separate arrangements to divide their finances, agree to maintenance payments if necessary, sort out child arrangements, and agree an ongoing parenting plan. While no-fault divorce should, in theory, make the process of divorce much more straightforward, it is just as important as ever to speak to an expert who can guide you through the process with practical, sensitive advice. Whilst the legal process is now easier, there is a real danger that those applying for a divorce themselves may not be fully aware that ending the marriage alone does not bring to an end the financial claims and ties between them. These remain ongoing despite being divorced. And whilst there are warnings that they also need to sever their finances with the granting of a clean break financial settlement order, there are many who fail to realise the risks they face in the future in not doing so. Whether you are making a sole or joint application, there are several important details that need to be carefully considered, and this is where Stevenson's can assist you.